let's see, Wednesday, oral argument, Supreme Court is the big administrative administrative state case that's going to decide the future of the administrative state in America.
You're going to have to deal with this one all the way from beginning to end, and I'm going to ask questions as we go along. What's the fact pattern? What's going on? What's the state of the case? And what are the issues?
So this was the case we discussed out of the Fifth Circuit that involved the SEC and their administrative law judges. It's now up at the Supreme Court because the Supreme Court has now taken cert. This is where what's happened is in the limited facts here, you had the SEC go after someone who was not a registered trader, wasn't registered with the agency. No consumer filed any complaint about him. No client filed any complaint about him. For whatever political reason, they decided to go after him. And what's extraordinary is, thanks in part to poorly written laws, but also due to the misapplication and misappropriation of the power under those laws by the SEC, this case is a perfect example of the problem of the administrative state. So we have separation of powers for a reason. Congress has to pass the laws. The president is the only one who can enforce the laws, or his delegates. And the judiciary is the only one who can adjudicate disputes concerning the laws. Yet the SEC usurped all three. The SEC was deciding legislatively whether they would bring a case in court or whether they would bring a case in their own SEC courts.
Administrative tribunals.
That's correct. Administrative law judges hired and retained by the SEC and who couldn't be fired by the President of the United States without special things.
We have this in Canada, and everyone in the States refers to them as communist tribunals. You have administrative courts, administrative judges. They don't even have to have been practicing lawyers for 10 years, as with normal judges. They determine their own rules. They enforce their own rules. And there's deference given to interpreting their decisions. I mean, this is what makes Canada what it is, and maybe the States will fight back against it. Sorry, so carry on.
Yeah, that's exactly right. That's what the administrative state has become. And they've done so by usurping powers the Constitution explicitly prohibited them from getting, where they're outside of the legislative branch, yet writing legislation. They're outside of the judicial branch, yet they're adjudicating disputes. And they're outside the elected head of the executive branch, even though they're the ones enforcing the law and executing the law. So it's extraordinary. You have an administrative state that is the origin of the word deep state. The word deep state is a derivative of the word dual state. The dual state doctrine dates all the way back to the late 19th century, late 1800s, when an author at The Economist was trying to explain how Britain could have a system of government that was indifferent to changes in election outcomes. And their theory was, well, really, we're starting to see a, quote, dual state. A state within a state of its own that isn't subject to political pressure because it doesn't hold office pursuant to elected office. It pursues office pursuant to these civil service reform codes that the professional class and the managerial class imposed on the rest of us in the late 19th century in the name of opposing corruption. And they usurped that power, and as that doctrine was expanded and extended by Germans and others who came over to try to explain the rise of fascism in the 1950s and 1960s, looking back on it, and they said a key problem was this rise of a dual state. And when you applied that dual state doctrine to the national security apparatus, the military-industrial complex, the intelligence community, a famous leftist of the late 60s described it as a deep state, a dual state that is deeply entrenched and is in key positions of unique forms of power with military, law enforcement, surveillance capabilities, with the capacity to extort or blackmail anybody, or bribe anybody, or engage in various extra-legal violence anywhere around the world or domestically. As in this past week, we had the commemoration of the assassination of President John Kennedy done by the deep state, but covered up by a range of people. To this day, in substantial part by the mainstream media. So, but the key, their legal key to their power is usurping constitutional authority they were not given by the founders. And so this case challenged all of it. It said, first of all, the Seventh Amendment to the United States Constitution gives us a right to trial by jury in any matter of civil penalty and I've argued this against contempt fines, argued this against sanctions being issued by courts. If at any level, if it involves taking money or property from somebody, got to be a jury first. I've long argued that. Courts have ignored it. Finally, the court stepped in because here you had these administrative fake courts issuing civil penalties into the hundreds of thousands or millions of dollars. That clearly was a Seventh Amendment right. To give people an idea, this goes all the way back to the Star Chamber. This goes all the way back to the Revolution. I mean, the Star Chamber was usurping jury trial rights that had already been established dating back to the Magna Carta and before in Britain. It's all the way back to the 9th century in Britain. Go to the Norman Code and all the rest. And then the British government did it again during the Revolution. And how they were doing it was they were doing civil fines by assigning it to vice admiralty courts and thereby avoiding jury trial rights. Because when they went to jury trial, one of my great predecessors, Patrick Henry, back when juries had sentencing power like they were supposed to, as well as judgment power, he said, give me liberty or give me death. And they issued the lowest possible fine to screw the government. So the British government was like, screw that. We're not going to let these colonists judge their own disputes. We're going to stick it we're going to call it a admiralty jurisdiction issue and stick it into vice admiralty issues and circumvent. And it was such a source of outrage. It led to the Seventh Amendment's adoption in the Bill of Rights. And here we are back with the federal government saying, no, this is public rights. Public rights, by the way, are things that you have only because the government gave it to you. This is like a government franchise, government license, government benefit. Has never meant to apply whatsoever to constitutional rights. Never meant to apply to their ability to take my money and property that was never the government's to begin with. That's the best way to understand public rights. It's property I have only because it came first from the government. The civil penalties are not money that came from the government, as much as the government might like to pretend everything comes from them. And so the first problem was this violates the Seventh Amendment. The second problem is they're doing legislation because they're deciding whether to go to court or whether to go to their in-house courts. And by the way, when they went to court, they would only win 60% of the time. When they went to their in-house courts,
95.
100. 100.
Damn it.
They were hitting 100%. These corrupt hacks were so partisan, they couldn't even at least throw somebody a bone now and then.
It's the Jose Canseco of administrative tribunals. It's amazing.
Yeah, absolutely. And so that's called the non-delegation doctrine. The Congress cannot give its legislative powers to the executive or judicial branch. The executive cannot give its judicial powers or its executive powers to the judicial or legislative branch, and the judiciary cannot give its judicial powers to the executive or legislative branch. And yet that's what's happening. They're usurping all of them without any constitutional authority. And so that's a violation of the non-delegation doctrine for them to even have that power to decide courts or in-house courts to begin with. And then you have the last problem, which is the take care clause, says the president's got to be able to fire people because he's the only elected head of the executive branch. This corresponds to the nonsense of bringing a insurrection claim against the president. How does the president insurrect himself? It's ludicrous. But also it relates to the classified documents cases. It's classified for him. So how can he violate something that's for him? It's just insane. It turns our entire Constitution on its head and puts the administrative state at the top and the president underneath. And that's what the SEC was doing by removing these judges from the power of the president to even appoint them in the first place or remove them later. And so that violates the take care clause in Article 2 of the U.S. Constitution. So it goes to the core of the abuse of power of the administrative state. And if the Supreme Court goes along with the Fifth Circuit and says, yeah, they're right across the board, and maybe even expands some doctrines, it will eviscerate the illicit power of the administrative state legally in America.
Whoever's watching now has to snip and clip that last 2 minutes. I've been thinking that the entire time. Please. Thank you. Tag me. No, Robert, I wanted to bring up the Seventh Amendment. I've never read it, actually. In suits at common law where the value in controversy shall exceed $20, the right of the trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any other court of the United States than according to the rules of common law. Robert, when people say the Constitution is a living, breathing document, what would the $20 be today if you had to interpret it? It can't be $20 because that would be every lawsuit.
Well, I mean, That's a good quote. What would it be? I'd have to go back and look. It'd probably be pretty, maybe 200,000.
Okay. And so it would be a $20 multiplied by 2 every 7 years type thing. That's hilarious. I didn't even realize. I'd never.
And they've interpreted the common law provision to be if you had a right to trial at the time of the Revolution, to trial by jury, you have a right to trial now. And historically, that common law has been anything that involves money. Period. Equitable courts, equitable jurisdiction. It goes all the way back to you used to have the civil courts you'd go to in England, and then you could appeal in the alternative to the court's conscience and the chancellor, and that's who the court's conscience was, the equity powers. And those equity powers end up forming the basis of trust law and a bunch of other things that a lot of people get even confused on today when they're trying to do tax planning and asset planning and things like that. But it was only those things that appeal to the king's conscience that were excluded from the right to trial by jury. Everything else was right to trial by jury.
And now I think like a $50 parking ticket can result in thousands of dollars of fines and jail time. So like when everyone was saying the COVID tickets were just tickets, no, they add up and they can land you in jail. Now, but hold on one second.
And the Seventh Amendment is the civil right to trial by jury. The Sixth Amendment is the criminal right to trial by jury.
All right. Well,